For example, federal courts cannot issue advisory opinions. That is a naked request for legal interpretation unrelated to any actual dispute, since no controversy exists to adjudicate. Superscript 10, which reads, these are discussed more fully in Chapter 5. Back to the text. Because the line separating requests for advice from actual dispute resolution can be quite indistinct, courts have developed the requirements of adverseness and standing. Adverseness and standing. These concepts reflect the conviction that full and fair resolution of a legal issue require the clash of parties whose stakes in the outcome are real and immediate. There must also be some sort of a genuine disagreement on the merits. If two parties without actual quarrel file a friendly suit just to see how a judge will rule, they may lack the necessary incentive to make their best arguments. A fundamental tenet of United States constitutional policy is the concept of an independent federal judiciary. Federal courts exercise their day to day power without interference from the political branches. To ensure this, federal judges are appointed for life and assured that their salaries will not be reduced. At the same time, however, federal courts do not exist entirely outside the political process. All federal judges are appointed by the president, subject to Senate confirmation, and Congress completely controls the shape of the federal judicial structure. Article 3, Section 1 of the Constitution mandates the existence only of the Supreme Court and such inferior courts as the Congress may from time to time ordain and establish. And only the Supreme Court has its jurisdiction set in constitutional concrete. Congress can specify not only the number and types of other federal courts, but also the areas to which they may address themselves. 2 centuries of congressional tinkering have produced a set of general federal courts, which may consider everything the Constitution allows, and a sprinkling of specialized tribunals. The general courts are organized into 3 tiers. 1. 91 district courts hear cases on the broadest jurisdictional level. These lower federal courts conduct full trials, hear motions, you name it. Number 2, appeals from the district courts as well as from many federal administrative agencies are taken by 13 courts of appeals. Number 3, final review of all federal cases is reserved for the Supreme Court. That review is not automatic. Access to the Supreme Court comes only by way of a certiorari. Writ of certiorari, with which a with which the Supreme Court grants discretionary review, or as a result of few statutory provisions that require the Supreme Court to review certain cases.